technology. All these collect or process personal data. And this could range from customer data, employee records, or sensitive information like health and financial data. And with that, it poses a risk of data privacy and the need to protect this data. The anecdotal assertion that data is the new oil is now settled beyond debate. And with that, our focus today will be how can we move from paper compliance, where policies are drafted but rarely implemented, to a culture where data protection is embedded in the daily operations of the organization. To be able to do this, we shall go ahead and see how best we can build a data protection compliance program. And in our presentation today, this will be our presentation outline. We'll look at Can you confirm that you can see my screen?
Yes.
Just, I think I'm having an issue.
I think now, okay, it's back.
So our presentation outline will have an introduction basically, and then see how best we can have the key compliance obligations reviewed under the Data Protection and Privacy Act. We shall thereafter look at the overview of a data protection compliance program, what this basically entails, and then the benefits of having the same. And then lastly, we shall have a look at the consequences of non-compliance. What happens anyway in case we are non-compliant? And then lastly, we shall have a Q&A session where we get to interact a little bit more. So I'll delve right into it and look at the key compliance obligations under the DPPA. The very first, like you may be aware, is to do with renewal and registration with the Personal Data Protection Office. Any organization that collects or processes personal data is mandated to register with the office, and that is pursuant to Section 29, subsection 2, and Regulation 15.1 of the regulations. And it goes beyond just registration. This also entails renewal of the same, which should be done annually. And I understand that for many of us here, we may have our entities registered with the office, but one of the other key compliance obligations is to renew that registration on an annual basis. Then the other is to do with adherence to the data protection principles. These principles are provided for within Section 3 of the Act. And what this basically entails is that as we go around our operations within our organizations, we need to be aware of these principles of minimality, of lawful basis as to why you're collecting or processing personal data, things to do with storage and how long you can retain that information. All these principles need to be embedded within the operations of our different organizations. The other is to do with security measures for protecting personal data. These are provided for under Section 20 of the Act as data collectors, data processors, and data controllers within our organizations. We need to make sure that we adhere to the required security measures to protect the personal data that we engage with. Then, of course, the other key compliance obligation revolves around the rights of data subjects. The different data subjects we engage with, the different clients, employees, do have a number of rights within the law, and there's need to protect the same and have procedures in place for them to exercise these rights. We also have what we call a data protection impact assessment, or what many may know as the DPIS, which are provided for under Regulation 12 of the regulations and mandate that whenever you are rolling out any new system that would pose a high risk to the individuals and their right to privacy, then there is need to make that DPIA and assess the kinds of risks that may arise and how best you can be in position to mitigate the same. The other compliance obligation is to do with the adequacy assessments. And this is in line with the cross-border transfers. And like I mentioned, that today's world is really a digital world. You find that data has to move across different countries, different economies. And with this, there's still the need and requirement to protect this kind of information. And within the law, it provides for the need to conduct an adequacy assessment to confirm that the country to which you're transferring to personal data has the adequate measures to protect the same. And then, of course, the last being filing of the annual compliance reports. This is provided for under Regulation 50 of the regulations, which requires that at the end of every financial year, every organization must submit their annual compliance report with the Personal Data Protection Office. So these are some of the key compliance obligations that we have within the law. And with that, we'll now look at the overview of the Data Protection Compliance Program. What does this program really entail? What should be included in this kind of framework? So having known what our compliance obligations are, a Data Protection Compliance Program is really a framework that ensures that personal data is collected and processed in accordance with the law. It entails embedding compliance within the Data Protection and Privacy Act, the policies and procedures, the daily operations of the organization, and building a privacy culture within the organization. So this kind of compliance program goes beyond just having policies and procedures, but it includes having a system of governance, of risk management, of controls, and a culture of accountability that spans beyond just the people and the technology used within the organization. Of course, this program must be tailored to the organization's size, the regulatory environment, as well as the data processing activities, and again, the risk appetite, what kinds of risks you could face within your processing activities. And these should be aligned with the international standards like the ISO standards, the regional laws like we have in Uganda, the DPPA, and any other privacy frameworks that may be applicable to the organization. So basically, that is what a data protection compliance program should ideally look like. We'll now look at what are the core components of this kind of compliance program? What should be embedded within this kind of framework? The very first is a governance structure. There is need to have a proper governance structure that defines the privacy leadership roles within the organization. Beyond having a data protection officer, which is a requirement of the law, to foster a culture of accountability and compliance within the organization, there's need to have defined privacy leadership roles. And this includes having things like a data protection committee that could have representatives from each and every department within the organization, right from risk and governance to IT, to legal, to HR, and the kind. Having these kinds of committees will go a long way in embedding the privacy culture at the core function of governance within the organization. And then the other is to do with having privacy policies and procedures. As an office, at the point of renewal, we do require every organization to have a data protection and privacy policy or an information security policy. Now, these policies are internal documents that speak to the internal functions and internal operations of the organization. What ideally employees should be aware of as they go about their roles. And beyond having these privacy policies, there is need also having the privacy notices, which are now outward facing, that speak to the general public on how they can, how their data is collected, how they can exercise their rights, and the kind. This can be pinned either within the premises of the organization or even on your website. And this again speaks to the spirit of and the principle of transparency that we talked about, which is embedded within Section 3 of the Act. So having these policies in place, and again, beyond just having them, having trainings for staff on these kinds of policies will go a long way in ensuring that, yes, you don't just have a document on paper, but you also have the implementation being done at the highest level. And the other component of this data protection compliance program is to do with the data lifecycle and classification management. Now, as an organization, it is recommended that you have what we call data mapping. Data mapping involves being in position to know the processes of data flow within the organization. For example, at the point of sourcing this information, who do you get the information from? Is it from clients? Is it from employees? And once you've been able to collect this information, who has access to it within the organization? What is the kind of flow? Is it from legal to maybe marketing? What individuals or departments within the organization actually have access to this kind of information? Having this information and data mapped out within the organization will also enable you to identify some of the risks that are posed within the data flow. And of course, when you identify these risks, you'll be in position as well to find measures to mitigate these kinds of risks. And this kind of data mapping should also include things like how you store your data, who you share this data to. Is it being shared to another third party for processing? For example, if you are an organization and let's say an NGO, and you have to pay your employees a monthly salary. So you contract a bank or you get the bank details and are able to share this personal information with the bank to be in position to pay their salaries at the end of the month. In that sense, the bank is a data processor, and there's need to have all this data mapped out and know who you actually share this information with. And beyond that, even the kinds of countries that you share this kind of personal data to. If you have donors, for example, in other countries, we talked about the adequacy assessments that need to be done. In this sense, when you map out your data, you'll be in position to know what kind of assessments you need to do, and again, be in position to fulfill your compliance obligations. And of course, even the classification of this data, you know that we have what we call the general personal data, which could include your name, your email address, but then you also have a special category of personal data. And this could include things like health information, and this could also be not only for the employees, but also for the different clients that we deal with. We also have information like the financial data, information about someone's religious or political affiliations. We're now in a political season. So all this kind of information is a special category of personal data. Being able to classify this information that, yes, this is the kind of personal data we collect, the general category, and then also the special, or what you call a sensitive category, will go a long way in ensuring that as you map out your data, you know what exactly to do in terms of protecting the same. The other is to do with the data subject rights management. And this involves, we talked about the kind of rights data subjects have: right to access the information, right to deletion of their data, or the right to be forgotten. And all these rights need to be exercised by the different data subjects. Of course, there are certain limitations to some of these rights. For example, if you're an organization and a financial institution, for example, that needs to also comply with other laws, like the Financial Institutions Act, which provides that you need to retain information for at least 10 years. And by that, I mean personal data for at least 10 years. And we also have now the DPPA, which is saying you need to only retain information for as long as you need it. On the other hand, you may also have a client who wants to exercise their right to deletion of their data. How do you manage some of these things? In this sense, if you have a data subjects rights management mechanism within the organization, you'll be able to tell that, yes, whereas data subjects have their right to erasure, you have particular obligations as well to fulfill. And in that sense, you may see that some of these rights may be limited to that extent. But nonetheless, there's need to have procedures in place that can actually enforce these rights. For example, do you have an email address where one can write to exercise their right? or do you have a telephone contact they can always reach out to in case any of their rights is being violated and need to have the same rectified? Having dedicated email addresses and contact points for the DPO and any other person within the organization that handles personal data will go a long way in ensuring that the organization is compliant to data protection and privacy and the other obligations within the law. And then, of course, this also entails having proper limitations of time on when to address some of these requests for access, because the law provides for a number of days, some being 21 days, others being 30 days, within which an entity can actually respond to some of these data subject access requests. So if you have proper documentation and proper systems in place to track some of these timelines, to go a long way in ensuring that you're compliant with what the law provides for. And then, of course, having a risk management system in place. We talked about the data protection impact assessments. The law provides that before you roll out any new systems that could pose a high risk to the different data subjects, there is need to conduct that kind of assessment and ascertain what kinds of risks may be posed. And you understand that even before you identify some of these risks, because, I mean, how are you going to do a DPIA before you map your data? Like we talked about data mapping. Through the data mapping process, you're able to know the kind of people with access to information, the kinds of measures you need to have in place, and what potential risks could actually be posed. So this data mapping, of course, now feeds into an inventory, the data inventory that ideally every organization should have. And this will have proper documentation of the record of processing activities of the organization. And then, of course, the other being to do with privacy by design and by default. In today's digital world, because of innovation, we've seen that a number of organizations have moved their operations to a digital system. They've digitized the operations and in a bid to catch up with the trend. But of course, with innovation now also comes the risk to the privacy of these individuals. So ensuring that as you build your systems, as you build your applications, you need to ensure that aspects of privacy by design, that the design mechanism of these kinds of platforms are geared to ensure that information is protected. That by default, you're having principles like data minimization being implemented within the system, that you're not collecting information that you will not ideally need. Having these embedded within our operations will go a long way in ensuring compliance with the law and a number of these procedures. Then, of course, the other being the third-party management. You realize that the biggest risk when it comes to data protection and privacy is to do with third parties. But again, no one is an island. We need to work with many of these third parties to process information on our behalf. For example, the banks and any other processors you may have, developers of an application and the kind. But you will notice that in most cases, as an organization, you may have procedures and practices in place to manage your data. But again, how sure are you about a third party that you're sharing this information to? Do they have similar measures in place? Of course, the law provides that even before you engage some of these third parties, there's need for you to have a contract signed between you and a third party, or what we call a data sharing agreement. And this will go a long way in ensuring that obligations of both parties are addressed in terms of privacy. This kind of contract goes beyond the standard contractual clauses we have on non-disclosure and confidentiality, but goes as deep as ensuring that in case of a breach, obligations are clearly stipulated within these kinds of contracts. So having particular due diligence conducted on third parties, ensuring that even before you contract them, are they registered with the office? Or if in a different country, are they registered with the Data Protection Authority in that country? Having all this kind of third-party management in place practically will ensure that you adhere to what the law provides for, protect the privacy of the different individuals you work with, but also be in position to fulfill your mandate as an organization. The other core component of a data protection compliance program entails the cross-border data governance. And like I mentioned, that these days we have a lot of data being transferred across borders because business has to be done. But again, with these kinds of data flows, the risk to privacy also arises. The law provides that even before you share information outside Uganda, there's need for you to conduct that adequacy assessment that we talked about earlier on. And having these assessments done will go a long way in ensuring that you protect the information that you're collecting, but also do business as today's digital world provides. But again, you just need to be alive to the fact that this information could still be subject to misuse or unauthorized access. So having that due diligence done, having those assessments done to ensure that this kind of data flow does not impede the privacy of these individuals will go a long way in ensuring your compliance journey to the DPPA. We'll now look at the other core principles or components, which include data security breach management. How do you handle data security breaches within the organization? Because, I mean, some may think, oh, we are too small, we may not be targets to cyber criminals, but you need to be alive to the fact that anyone can actually be a target to these cyber criminals. And with the growing trend in the use of digital platforms, the risk of data security breaches also arises. But beyond knowing that when this kind of breach happens, you need to report to PDPO immediately, do you have an incident response plan in place? You should ideally have an incident response plan that speaks to what each and every one within the organization is required to do in case of a breach. And to make this even more practical, you could roll out a pseudo breach within the organization, or what we call the drills. Maybe send out a phishing email and see just how many people will be in position to click on the same. This will speak to you and know that, okay, I think we need to do more in terms of training of some of these employees on how to manage security breaches. Having these breaches actually done, having the drills done, and seeing people's reaction will be in position to inform what ideally would be done in case an actual breach actually happens, in terms of containing the breach, in terms of recovery of the data and the kind. So practical ways on having these breaches in place beyond just the policies will go a long way into feeding that. Then of course the trainings and awareness of staff and any other third-party providers that you work with. This training should be done regularly. You shouldn't ideally only have, let's say, one training in the year. Have regular trainings on a number of different topics, not only on the overview of the Act and what the Act provides for, but again, like I mentioned, trainings on maybe how to respond to data breaches, trainings on how to actually resolve some of these data subject complaints that may arise will go a long way in ensuring that you have a practical approach to the compliance obligations within the organization. Then, of course, the other is to do with monitoring and auditing. As a data protection officer, you're required to conduct audits within your organization. The internal audits, even before PDPO comes in, and maybe any other external auditors that you may have coming to audit you, beyond the financial audits that organizations have. There's need for you to have audits geared specifically to data privacy. So having these audits done will go a long way in ensuring that you address the gaps that may be identified and be in position to comply even before the office comes in to do these audits. So that self-regulatory assessment will ease your compliance and will enable you know what exactly you need to do to adhere to the provisions of the Act. And then, of course, once you have this framework in place, there is need to review the same. Have periodic reviews of this data protection compliance program, because as technology evolves, there's the risks as well that are posed with some of these technologies. For example, things like emerging technologies, the AI, the Internet of Things, are now one of the key developments in the digital space. But now, how these again affect your compliance journey or utilizing the same will go a long way in ensuring that you do those assessments, because some of these AIs, for example, have bias, have these biased algorithms that may ideally impede on a number of data subjects' rights. We've seen cases, for example, in the US, where we've seen people deploy AIs to organizations deploy AIs to sieve through candidates that have applied for jobs. And a number of them have been found either biased towards the Black people or the women, depending on how some of these AIs are built. So reviewing your framework will go a long way in ensuring that some of these gaps are identified and dealt with along the way. And basically, that's what the data protection compliance program should practically look like. We're now going to the benefits. Why should I even have a data protection compliance program in the first place? So this goes beyond registration, like I mentioned, because compliance is a journey. It's not a one-day event. And some of the benefits of having this data protection compliance program include things like ensuring adherence to the regulatory requirements, because like we started earlier on, listing some of the key obligations we have in terms of compliance to the DPPA and the DPPR. Having this kind of compliance program will feed into that kind of regulatory compliance that you're ideally supposed to have in place. So that's the very key benefit of having some of these programs in place. The other being that it improves the in-house data management practices. We've gone to organizations before for audits and inspections, and you find that maybe everyone has access to particular cabinets where personal data is stored, or organizations don't even have maybe access controls in place to restrict the kind of access to different areas. But once you have this data protection compliance program, it will be in position to improve some of your in-house data management practices, how best you handle data within the organization, ensuring that, yes, the principles are embedded within the daily operations, ensuring that the data is secure, ensuring that the data is of good quality and accurate as required within the law. Then, of course, it also builds customer trust and confidence, because then as a customer, if I know that you have some of these programs in place, I would definitely come to you and over maybe your competitor or any other person you may be in the same space. So having these programs will build that trust, especially given that personal data is being misused in a number of ways. But once you have these kinds of compliance programs, it builds that trust for customers and the different clients that you work with. Then, of course, it also prevents financial losses that may arise out of fines, litigation, and compensation. You know that the law provides for a number of fines in case either data is unlawfully disclosed or any of the offenses are committed within the law. It also provides for compensation to the different data subjects that may be affected by your misuse of their personal data. But having this kind of compliance program in place will go a long way, will actually be much cheaper than hiring a lawyer to go to court because you have a privacy matter, or even compensating a client because you fail to adhere to some of these principles within your operations, and also, of course, the fines that may arise out of this. So organizations are encouraged to have this kind of program to avoid such financial losses from arising. Then, of course, also averts imprisonment of staff. Like you may be aware that where a violation of the Act is found and is indeed proved, it goes beyond just an organization paying fines, because you may know that an organization that is found in unlawful disclosure is actually mandated to pay a fine of up to 2% of the gross annual turnover. Now, I know that is quite a big sum to many of the organizations. Just 2% of your budget or your annual gross turnover being paid in fines would impact on some of your operations. So, but beyond those fines, even the individual staff themselves that may be found in violation of some of these principles could be held accountable individually and face imprisonment. I know that these days, for example, before the president appoints anyone in a public office, for us, we're always on social media, already discussing their capabilities or lack thereof, even before the person is aware. But why? It's because maybe someone somewhere unlawfully disclosed this kind of information. But again, like I mentioned, these particular individuals ideally could also be held liable personally. Then, of course, the other being that it safeguards data subjects' personal information from unauthorized access. Once you have these measures in place, the practical measures to protect information, to ensure that only those that need to access information are actually the ones that do, and that data is shared within the confines of the law, will safeguard the information of your clients from unauthorized access. Then, of course, also prevents reputational damage. I don't think that any of the organizations we have here today would want to be out in the news known for mishandling people's personal data. A data breach could heavily impact on the reputation of the organization. So that's why there's need to ensure that you adhere to some of these principles, you have them practically embedded within the organization to prevent some of these reputational damages. And yet you could have built a brand or a name for over years, over 20 years, over 10 years, and this could go down just because of a simple breach happening. And this should show you why, ideally, you need to protect this kind of information. Then, of course, it creates a competitive advantage through data-driven innovation. Like I mentioned that, yes, in the era we're in today, you'll find that a number of organizations are now shifting to a digital space. They can maybe order for food without having to physically go to a restaurant. And this actually reaches me. But then once you're able to adhere to some of these principles, have this compliance program in place, to create that competitive advantage. If I know that if I order food maybe from restaurant A, my data will not be disclosed because I know they have a robust framework for complying to what the law provides for. So these are some of the benefits that we need to be alive to that come with having a robust data protection compliance program that goes just beyond having the policies and having actually procedures in place that speak to some of these policies. The implementation of some of these policies feeds into what the organization does at the end of the day in terms of compliance. But you could ask yourself, what happens anyway in case I don't comply? What is the worst case scenario? You may think probably non-compliance is maybe cheaper than compliance. Why do I need to comply with the law, besides it being a requirement? Now, for that, first and foremost, you need to be alive to the fact that this could arise into a fine of up to 2% of the institution's gross annual turnover. Like I mentioned, that I don't think any of our institutions that we work in would want to be in the habit of paying fines of up to 2% of your gross annual turnover just because you failed to adhere to what the law provides for. So the other, of course, being imprisonment for between 3 months to 10 years. Again, from our different organizations, I don't think any of us would want to go to prison for up to 10 years just because you violated and can't adhere to what the law provides for. So this goes to tell you that, yes, data protection and privacy, having this program, the compliance program in place, goes to the root of the organization. It goes beyond just mid-level management, but actually goes to senior management and goes to the core of the organization, because the effects of non-compliance not only affect the clients that we deal with, but also affect the organizations where we come from. And we'll now look a bit at what has transpired in the past, where we have court decisions, we've had decisions by the Personal Data Protection Office in terms of non-compliance entities. Of course, the very first being one of the most recent, in the case of Frank Sekamo and others versus Google LLC, where we had applicants that lodged a complaint challenging the data processing activities of Google LLC. And of course, this decision is available on our website. You can always have a look at it. But in summary, PDPO ruled in favor of the applicants, determining that the respondents were in breach of various provisions of the DPPA and required them to take reasonable steps to demonstrate their compliance. And of course, this involves having a compliance framework that ideally the office is in position to have a look at. Then, of course, the other case being the case of Uganda versus Mogolusi Ronald, where we had a particular company, digital lending application called Quick Loan that was owned by Mogolusi Ronald. And this particular individual was operating this application without being registered with the office, collecting personal data without being registered with the office, and again, also processing it without the consent of the data subject. And this matter went to court, and the accused entered into a plea bargain agreement as well as a reconciliation agreement with the complainant. And this particular court proceedings were stayed and resulted into a fine. So again, you see that some of these are being put in place. You see organizations paying fines, people being imprisoned because of failure to comply with the law. So, like again, I don't think any of us is willing to go to prison just because we fail to adhere to what the law provides for. And then, of course, we also had an investigation that revealed that a border sharing application here in Uganda failed to inform its users about sharing their data with third parties for analytics, because I know that for many of us that may use some of these border riding applications here, we had one that was sharing information to an American company for analytics to confirm when do actually clients on board onto this application most, so that they're able to give them discounts. But the investigation of the office revealed that indeed this was being done, this kind of data sharing was being done without the consent of the individuals. So this again speaks into the aspect of transparency, the principle of transparency as provided for, and why as organizations we need to adhere to what the law provides for. These are some of the court decisions and those of PDPO in regards to the Act. And I hope that as entities, as individuals, you're also able to learn a thing or two from some of these decisions. And as we go into the final stage of our presentation, in case of any regulatory guidance or in case of any further clarity, you can always reach out to PDPO. We are located on Plot 32, Lumba Avenue, on Padre Pio House. And in case of we also have resources on our website. We have a number of guidance notes and a number of decisions that we've passed that you could ideally have a look at to inform some of your data protection compliance programs. With that, I want to thank you so much for listening to me and hand this back over to you, Anita. Thank you.
Okay, thank you so much, Jordan, for that wonderful presentation. Let's now go for the next session, which is the Q&A. Members, if you have any questions, kindly type them in the Q&A panel. Okay, so, the first question I'm going to take from the Q&A Jordan, can I take like 3 if you don't mind? I could be taking like 3 at once and you respond to those.
That should be fine.
Okay. So the first question, Patrick says, I am developing a UGC professional social media platform. We have developed several legal documents, privacy policies, user agreements, cookie policies, and others. According to the Data Protection and Privacy Act, are these policies to be registered with PDPO? I think she needs clarification on what policies are required under the DPPA. And then the second question, recently the AG guided that NGOs are relieved of obligations to register with the NGO Bureau. This is because of the constitutional freedom to practice religion and to avoid state interference in spiritual matters. So for NGOs that are purely religious, can we get clarification if the requirement to register with PDPO still applies? And then the third question I'm going to take. Thank you for the information, but I just wanted to know, like in most of the non-governmental organizations, the NGO Bureau always demands for some of the key information. I want to believe that is personal data. Is it right in accordance with the Data Protection and Privacy Act? You could take on those 3 and then.
Okay, thank you, Anita. I'll start with the very first question in terms of registration of policies with PDPO. What we register at PDPO are organizations, or what we call data collectors, data controllers, and data processors, as defined by the law. Any person that collects or processes personal data ideally should register with us. So we do not register policies per se, but at the point of renewal of your certificate with the Personal Data Protection Office, you are required to have and submit a data protection policy or an information security policy. So it is only an attachment as part of your renewal application where we request for any of these policies. And why? It's because this policy feeds into aspects of accountability as an organization, because this is a principle provided for within the law. So what we register really is the organization, but with the policies, we ask for them at the point of renewal for that particular reason. Then when I got to the question of the requirement for NGOs to register with PDPO, yes, I'm aware that the Attorney General guided that for those religious entities may not be necessarily required to register with the NGO Bureau anymore. And that applies to the NGO Bureau. But when it comes to the PDPO, the law is very clear that every data collector, data controller, or data processor must register with us. And that registration is not it's not the same that happens at the NGO Bureau. So for us, as long as you still collect or process personal data, irrespective of what you do as an NGO, you'll still be required to register with the Personal Data Protection Office and renew your registration as well. Then when it comes again to the question of why the NGO Bureau collects particular information from you, I think for this, of course, I would have preferred if we got a breakdown of what kind of information is being collected, because, but just to guide, as long as the information is relevant for the purpose that they're collecting it, then ideally they can be in position to collect it. So what you need to determine is the relevance, or what they need to explain to you is the relevance of this kind of information, because it's one of the principles of the law that you should only collect personal data that is relevant for the purpose. So if the purpose is for registration, for example, or if it's for filing of maybe annual returns, and it is clear and it is within their mandate, then that would ideally be okay, unless this kind of information that is being sought is not relevant to the purpose for which it is being collected, is when ideally it would not be right. Thank you. I hope I've been able to address all those.
Okay, thank you, Jordan. I'll take the next 3 questions. Someone is requesting that you share costs associated with the registration. And then, do you have training programs in data protection and privacy? And how to start a data protection program? And then the third question I'm going to take, someone says, is it proper for deliverance churches to publish health-related data of their clients? Over to you, Jordan.
Thank you once again, Anita. So I'll start with the very first question again in regards to the costs for registration. What does it take to register with the Personal Data Protection Office? This registration only requires a fee of 100,000 for each organization that registers with us. And the same fee of 100,000 Ugandan shillings is what is paid at the point of renewal. And like I mentioned, that this can be done online. You can go to our website, that is pdpo.go.ug. You can click on register, and you'll be in position to fill in the application form and submit your application for registration. Then, of course, when it comes to the training programs, if we have any training programs, yes, as an office, one of our core functions is to make sure that we train and create awareness of the law within Uganda. And we do have training programs, and this is just one of them, where we have the monthly webinars, but also beyond the monthly webinars, you can always write to us on the email address I just shared, that is info@pdpo.go.ug, requesting for training specifically for your organization. And this can be worked out. We can always arrange and have a training done for your staff. I think Anita has shared the email in the chat. And as an office, we are also in final stages of developing a curriculum for data protection officers and any individuals who may be interested in the field of data protection. This curriculum will be rolled out very soon, most likely by the end of this year. And we'll go a long way in equipping DPOs and any other data protection practitioners with what they need to know in terms of data protection and privacy. The other question is to do with how to start a data protection program, a compliance program. Of course, this is something that needs to be started as small as possible, depending on what you have and the kind of volumes of personal data you deal with as an organization. Have this again, we talked about things to do with data mapping, things to do with the governance structures. If you have a buy-in from the top senior management on some of these data protection requirements, then it becomes easy for you to develop this kind of program. Have, for example, maybe an Excel where you track some of these timelines in terms to do with maybe the kinds of timelines you have to respond to data subject requests, the kinds of timelines you have to respond to complaints, and when you have to file your annual compliance reports, when you have to renew. Having this kind of track and kind of data mapped out is a good way to start on this kind of program. Having training scheduled as well, maybe spread out through the year, maybe quarterly or monthly, depending on how best you want to do that. Again, we'll go a long way into feeding this kind of data protection compliance program for the organization. On the question of having deliverance churches that pin people's health data, of course, the law provides that before collecting or processing someone's personal data, one of the lawful bases that are based on is one, that you've obtained consent of the data subjects. So it would be important to find out if indeed this data is being collected, maybe published after this kind of consent has been sought. But beyond consent, of course, there are other lawful bases of collecting or processing personal data. So you would want to understand, and of course, you have a right to ask for some of this information from these maybe organizations that publish this kind of information? What lawful base they have to actually share this kind of information? Is it because they have a legitimate interest? Is it because they have a legal obligation to fulfill? That will go a long way in understanding whether there's a violation of these kinds of privacy rights or not. I think I can take on the next questions, Anita.
Okay, thank you so much, Jordan. I have seen questions around data mapping. About 2 people, I think, needed guidance on how to do data mapping. I don't know what brief guidance you can provide on that. And then there are about 2 related questions. One says, can I be a data protection officer for more than one organization? And then the other question is, can a data protection officer based outside Uganda be appointed for a Uganda-based organization, and what would the requirements be? Can I let you first take those?
Yeah, sure. I'll start with a question on data mapping. Data mapping, basically, like I mentioned, that it is the process that records your kind of data processing activities, the kinds of sources of your data. It categorizes the classification of this data, whether it is special personal data or it's general personal data. And of course, even who has access to this kind of information and who this information is shared to. That is the entire process of mapping out your data. It's like a map. It's like you draw a map that, that many of us may know. And as an office, we've come up with a template of data mapping and a data inventory. In the compliance toolkit that we developed, some of these tools are there to guide on what needs to be done and needs to be included in this kind of data mapping. So you can always reach out to the office, again, through the email address provided, requesting for some of these templates and maybe any other guidance or clarity in the entire process and journey, because it's not a one-day event that you're going to sit and, feel in and know that, yes, I'm now done with mapping, but it's a continuous assessment. So you can always reach out for a template that will give you better insights on what needs to be included in this kind of mapping of your data within the organization. And then when it comes to the DPO, if one can be a DPO for more than one organization, yes, one can be a data protection officer for more than one entity, because the law provides that, yes, one can be designated as a DPO. And you may find that we have some organizations where we have law firms or lawyers as their DPOs. They outsource because they can be both internal but also outsourced. So you have some that have outsourced lawyers to be their DPOs, and you find that maybe a law firm is representing, let's say, about 5 clients and have DPOs within this organization. Maybe it's important to note that, yes, you may have, let's say, one law firm as, or even any other consulting firm as a DPO for about 5 organizations. But what we would require you to have is that you need to have individual people within the organization, within the law firm, within the consulting firm, individuals that are actually responsible as the DPOs, beyond just having the corporate entity being the DPO. For DPOs outside Uganda, yes, it is possible. The law doesn't limit on if you should be within Uganda or not. So you can have a DPO for an organization, and this DPO could be outside the country. But as best practice, we usually encourage entities to have DPOs within Uganda for one particular purpose. And that is because you know that the DPO acts as the liaison point between the office and the organization. So having someone within the office and within the country, someone who can easily access, maybe in case you want to conduct audits, you want to conduct investigations, or in case they need to respond to particular complaints, it becomes easier if someone is actually here compared to having DPOs outside the country. But nonetheless, it is still possible to have a DPO outside Uganda. I think that's it, Anita.
Okay, thank you so much, Jordan. I can see we just have 1 minute to go. Members, you'll bear with us. I am going to have to take only 3 questions, and then we will close it at that. If your question has not been answered, we have quite a couple of questions that haven't been answered yet. So if your question hasn't been answered, please feel free to reach out to us. You can call us on any of the contacts on our website or send us an email. So, Jordan, I'm going to take, I think, about 3 more questions. Someone says, do fines also apply to organizations which are audited and do not comply with some policies? I want to think they wanted to say, do fines also apply to organizations which are audited and don't comply with some laws? And then someone is asking, how do we conduct cross-border assessments? And then the last question I would take, someone said you have talked about DPIAs. Could you kindly advise on whether there are explicit guidelines on how these can be conducted? Over to you.
Thank you, Anita. I'll start with a question on the fines, if they apply to organizations, I think that don't comply to some policies or to some laws. As a matter of fact, as long as you are held in violation of the Act, the fine will apply. So whether you're an entity that that has been audited before or any other case, as long as it is indeed proved that you were in violation of the Act or it's what the obligations that it provides for, then you'll ideally be required to pay the fines, depending on the gravity of the offense. And the other question to do with cross-border data flows and how these adequacy assessments can be done. Again, we have a template as an office for these cross-border adequacy assessments. So you can always reach out and these templates can be shared with you. But just give you a brief overview what this kind of assessments entails. One, it includes things like comparing if the country you're transferring to personal data has a data protection law, like we have here in Uganda. And if they do have a data protection law, do they also have an office, an implementer, like we have the Personal Data Protection Office here in Uganda that enforces this law? And beyond having those two, what does their law actually provide for? Making a comparison and analysis of our law and the law of the country to which you intend to transfer this data to. If, for example, they have the similar rights like we do have in Uganda, in case their rights are violated, how can they actually be, how can they be protected? And also comparing things like if this Ugandan's personal data that is being transferred to that country can actually be protected within that law. Because we have laws, for example, that only protect personal data of citizens and don't protect information of non-citizens. So having all this comparative analysis and also includes things like even the political environment of the country, because yes, we may have a country that has this law in place, but what does their political climate look like? Do they actually have respect for individuals' rights, including the right to privacy? What do their court systems look like? Do the court systems actually work? So having these comparisons is what is embedded within this kind of adequacy assessment. And at the end of the day, you're required to make a conclusion based on your analysis if this country has adequate measures to protect the kind of information you're sharing or not. But again, the template can always be shared to just give you better context on some of these things. Then for the data protection impact assessments, and if there are any guidelines to speak to that. For the DPIAs, of course, beyond what the law provides for under Regulation 12, that where it is on a large scale kind of processing, or if it is going to pose a high risk to the data subjects, beyond that, as an office within the data protection, the compliance toolkit for MSMEs and fintechs that we developed, it has some guidance notes on a DPIA, how it should be conducted, what should be looked at, what kind of assessment do you make to even know that I need to do a DPIA, and what kind of processing activities do I need to be aware of before conducting this DPIA. And beyond those guidance notes, we are also developing guidelines as an office, because we notice that there are a number of areas within the law that may be a bit gray. So as an office, we're developing guidelines that will speak to a number of these areas, including the DPIAs. So there'll be a guideline on the DPIA, how it can be conducted, when can I conduct it. And of course, it's important to know that it's not a tick box that you've conducted and it's done. A DPIA is a living document that needs to be reviewed over time, depending on any changes within the processing activities. So these guidelines, I think, should be coming out most probably next year. Early next year, we should be in position to have these guidelines out that will speak to DPIAs, to the retention periods that we have within the law, because you may notice that the law provides that personal data should only be retained for as long as you need it. But then how can I determine that? That will still come out in those kinds of guidelines that we are developing. Even for the data protection officer, we've had people ask questions. What kind of qualifications must a DPO have? Should they be legal? Should they be IT? Should they be admin? All this will come out clearly within those guidelines that we shall be developing as an office. Back to you, Anita.
Okay, thank you so much, Jordan. Let me get back to you for parting shots, and then after that, I will close the webinar. Do you have any parting shots?
Well, my parting shots are that I just want to make a call to action to the different organizations, the different DPOs. You need to ensure that you have this kind of data protection compliance program within your organizations. It is okay to start small, but build over time, build steadily to ensure that you shift from just having policies, but actually having procedures and a culture of privacy within your organization. And like I said, compliance isn't a journey, it isn't an event, it is a journey. And it is something that we need to build over time in the entire compliance journey. Thank you so much for listening to me. And back to you, Anita.
Okay, thank you once again. And members, for those asking for the presentation, it will be shared with a recording on the emails used to register for this webinar. And if you have any questions that haven't been answered, feel free to reach out to us on the email that was earlier provided, or you can check for the emails and contacts on our website and reach out to us, and we'll be able to respond to you. Again, thank you so much, all of you, for joining us today. We hope you found the discussion insightful and the ideas shared will be helpful in your work. A special thank you, of course, to our speaker, Mr. Jordan Magala, for sharing your expertise and perspectives. If you require anything, like I mentioned earlier, please feel free to email us after this webinar. And we have an open door policy. If you want anything, if you have issues with registration, I noticed most things came up around registration. There are kind of a couple of concerns. Please feel free to walk into the office and we'll be able to support. Again, thank you so much, and we look forward to seeing you at our future webinars. Have a great day and stay safe.